Hey guys, thanks for joining us. My name's Amor De Libasic, a financial advisor with over a decade's worth of experience, and today I want to talk to you about estate planning. Now, estate planning is one element of people's finances that over and over again I see no time has been invested into. I understand that it's a slightly morbid topic. No one wants to think about their own death. No one wants to think about their own disability. But ultimately, there are people in our lives that we care about. If we don't have this paperwork sorted, they could be put at risk, and our assets might not necessarily be dealt with in a manner that's aligned with our goals. So if we think about estate planning, first of all, we have to understand that there's both estate and non-estate assets. Some examples of non-estate assets that most people would have would be things like a property owned as joint tenants, or your superannuation, or an insurance policy. These non-estate assets are not governed by your will. Your will could say anything and it wouldn't necessarily have any impact whatsoever on these assets. For example, your will might say that you want all of your assets to go to your children. However, you own a property as joint tenants with your wife. In the event of your passing away, that property will just become 100% owned by your wife. On the other side, we have estate assets. Estate assets are assets which are governed by the will. Examples would be cash in your personal account, a property owned as tenants in common, investments in your personal name such as properties, shares, cars, collectibles, etc. These assets are governed by the will. Now, when we're thinking about estate planning, there are really four components we should look at: the will, a power of attorney, a guardianship agreement, and superannuation beneficiary nominations. If we start off with the will, if you don't have a will in Australia and you pass away, you're considered to be intestate. What this means is you have no will, and so the governing law of each state will apply in the division of your estate. Each state is different, and each state has slightly different rules, but effectively it's a formulaic approach to saying if you've passed away and you have this particular situation, this is what the government deems your division of assets will be. Now, for many people, the actual division of assets might align with what they want, but for many people it may not. So in order for you to be sure that your assets are actually being distributed in line with your goals, you need to have a will. Now, if we examine wills, there are various elements that you can include in a will. You could have a simple will on one side, all the way up to a more complicated structure like a testamentary trust. The right will for you will depend on your particular circumstances. The more complex your circumstances and needs, the more complex the will could be. Ultimately, however, you want to make sure that the will aligns with your goals and is appropriate for the assets and the need of the family. If we then move on to a power of attorney, a power of attorney is a document that provides someone with the power to step into your shoes from a financial perspective. Now, there are different types of power of attorney. A simple power of attorney will apply to someone before the point of mental incapacity. We would just call that a power of attorney. That person can then go and do your banking for you. They can sign a contract for you. They are you from a financial perspective and have to act in your best interests. From an estate planning perspective, we would typically look to utilize an enduring power of attorney, which endures past the point of a loss of mental capacity. A normal power of attorney would typically turn off at the point where you lose mental capacity, while an enduring power of attorney endures past that point. That means if you have a stroke or a cancer or something happens to you and you no longer are able to make financial decisions, that power of attorney can jump in and make sure that you're taken care of. We'd also look at something called an enduring guardianship agreement. Now, guardianship is very similar to a power of attorney, except rather than dealing with the finances, it's dealing with your care and lifestyle decisions about how you're going to live and what your particular circumstances are going to look like. In effect, this person becomes your guardian. The final thing to think about are your beneficiary nominations inside super. Many people have not made beneficiary nominations inside super, and this, for various tax reasons, can be problematic. So there are two pieces of legislation which determine who can benefit from superannuation and whether this benefit will be tax deductible or not. The Superannuation Industry Supervision Act tells us who can be a beneficiary of superannuation. Some examples are your spouse, your children, those with whom you're financially dependent, and those with whom you have a relationship of financial interdependency, as well as your estate. Now, the Tax Act tells us who can benefit from our superannuation without paying tax. Those are your spouse, minor children, people who are financially dependent upon you, people who have a financial interdependency with you. The estate cannot be a tax-free beneficiary, neither can adult children. And so you don't have a perfect overlap between who can receive superannuation and who can receive superannuation tax-free. So it's important for you to consider who you're pointing your superannuation to, because if you just elect the estate and ultimately you wanted that money to go to your spouse, because they're a tax dependent, they could have actually received that money directly tax-free, and you may end up with tax problems if it first hits the estate. Now, one of the more complicated elements that we might actually introduce into estate planning, and I'm going to spend a little bit of time on now, is what's called a testamentary trust. This would be included in a will. You have two types of trust. You have an inter vivos trust and a testamentary trust. A testamentary trust is established in someone's last will and testament. It doesn't exist until the person passes away. This can be an exceptionally useful vehicle for a number of reasons. If you have a simple will, for example, and you pass away, your estate will go to your partner, and whilst at the onset that might seem appropriate, there are a number of issues with that. What happens if your partner later remarries? What if they then get divorced? And their new spouse takes a significant portion of the wealth that you've left behind for your children? What if you both pass away and then your children end up inheriting quite a large estate when they turn 18? It may have been better to smooth out the actual transition of those assets and have some protective mechanisms in place so that rather than getting everything at the age of 18, they could get something at 18, 21, 25, and 30, aligned with where they would be at those various life stages. In addition to this, a testamentary trust provides us with asset protection and a high degree of tax flexibility. From an asset protection perspective, money that's distributed from the estate to the testamentary trust is held separately from the beneficiaries. So in that first example, where I pass away and the money goes to my spouse, well, if it went into the testamentary trust, that would be held separate from my spouse, and therefore the new partner wouldn't have a claim upon it. Equally, if both spouses were to pass away and the money is left behind for the children, because it's held in a trust, if those children were to get married and then divorced, it would have a degree of protection. If the children ended up getting into bad debts, well, that money, as it wasn't personally owned by them, would be held separately from their account and therefore not subject to litigation. If you have minor children, it can be exceptionally useful from a tax perspective, because what it allows you to do is treat each of the children as an adult from a tax perspective rather than a minor. Now remember, minors pay approximately 47% pretty much from the get-go. So if you have the marginal tax rate to utilize for a minor, it's going to be far more effective than paying them and having to pay the top 47% tax rate pretty much straight away. Estate planning is important, and so it's definitely worth sitting down and thinking about these different elements, planning out who you want your assets to go to, in which form, and how you can put different measures in place to protect yourself and your family. I hope you've enjoyed that video. As always, please like, comment, and subscribe. If you've got any questions or comments on estate planning or any other elements of finance, please let me know, and we'll jump into it as quickly as we can. Thank you, and good night.